there is an enormous split between what people are saying regarding the Department of Justice. I keep hearing two things over and over. On one side, they're saying Trump's DOJ is the most pro-gun Department of Justice in history. And on the other side, they're saying Trump betrayed gun owners. The truth, like most things, is more complicated than that. Let's walk through what the DOJ has actually done under the Trump administration, what helped gun owners, what hurt them, and then we'll break down the most recent DOJ filing, where they're arguing that knives are not protected under the Second Amendment. Let's talk about Trump's DOJ under his first presidency. Let's talk the positive. Under Attorney General Jeff Sessions, the DOJ revived the Project Safe Neighborhoods. Their emphasis was simple: target the violent offenders, gang crimes, and felons using firearms, instead of pushing for new federal gun laws. From a gun owner's perspective, this was great. The DOJ wasn't lobbying Congress for more sweeping restrictions. Instead, it was saying, enforce existing laws against criminals, rather than further hurting law-abiding citizens. And despite intense political pressure from high-profile shootings, this DOJ did not push for nationwide bans. And that restraint matters, especially at the federal level. But now let's talk the bad. The bump stock ban. In 2018, the DOJ, through the ATF, reclassified bump stocks as machine guns. Not through Congress, not through legislation, but just through administrative rulemaking. And overnight, lawfully owned property became contraband. Owners were told, destroy them, surrender them, or become a felon. This was the single largest federal gun ban that had happened in decades. And it happened under the Trump administration. It happened under a Republican administration. And even worse, the justification was executive interpretation, not a vote by the representatives of the people. The Supreme Court eventually struck this down, but the damage was done. A little bit more bad happened at that time also, where Sessions issued DOD guidance encouraging prosecutors to pursue the most serious provable charges. For most gun owners, this doesn't really matter, but edge cases involving paperwork errors, technical violations, raised the stakes significantly. The approach didn't really distinguish between your violent criminals and your regulatory offenders, nearly as much as it should have. Now let's move on to Trump's current DOJ under Pam Bondi. There's a lot of good here. For the first time in modern history, the Department of Justice has created a Second Amendment task force, established a Second Amendment section within the Civil Rights Division, and has begun suing governing bodies over their unconstitutional gun restrictions. That's not defensive litigation, that's offensive enforcement. And that's what we've needed over the past decades of slowly getting our rights chipped away. Two things off the top of my head: they're suing Washington, D.C. for banning AR-15s, and they're suing the Virgin Islands for excessive permitting delays. And this is unprecedented. Historically, the DOJ has defended gun laws. Now it's challenging them. Pam Bondi has also rolled back the Biden-era zero-tolerance policy. Under that policy, FFLs, gun dealers, they were losing their licenses over minor paperwork infractions. And the rollback doesn't stop enforcing the laws that exist, but it restores discretion and proportionality. And for FFLs, that's a huge relief. But now I want to get to the bad of this Department of Justice, which we're seeing right now. The DOJ just filed a brief in a federal appellate case, appellate, involving switchblades. The DOJ's position: automatic knives are not protected under the Second Amendment. Let that sink in. At the same time that the federal government is suing states for violating our rights with firearms, it's defending a federal ban on certain knives. They're arguing that they're not arms, as the Second Amendment defends. They're saying they fall outside of historical protections. Weapons like daggers and knives have been historically regulated. And this matters beyond knives, far beyond knives. Because once the government convinces courts that some commonly owned arms fall outside of the Second Amendment, that logic doesn't stay contained. Because these cases will dictate how courts think about common use, dangerous and unusual, and what counts as an arm at all. People should be watching this very closely. Before we move on to the next part, what's the takeaway so far? Trump DOJ 1.0 really hurt gun owners with the bump stock ban. Trump DOJ 2.0 is taking the most pro-Second Amendment stance in DOJ history yet is seemingly willing to defend federal weapons restrictions when it's convenient for them. This is not left versus right. It's about the government resisting limits to power, even when it claims to support your rights. The Second Amendment doesn't defend itself. It depends on courts, pressure, and citizens actually paying attention. And that's why stories like this matter. Now I'm going to talk about swords, but bear with me, I'm getting somewhere. When the Second Amendment was adopted in the 1791 Bill of Rights, the word arms was a very specific, well-understood meaning. It did not mean firearms. It meant weapons suitable for personal or militia use. And bladed weapons were unquestionably part of that category. Founding era dictionaries determine arms broadly. In Samuel Johnson's Dictionary of 1773, arms is defined as weapons of offense or armor of defense. Legal and military usage treated swords, bayonets, knives, pikes, and firearms all as arms. No founding era source limits arms to gunpowder weapons. A person in 1791 saying, "He bears arms," they might just as easily be saying a sword on his hip as a musket on his shoulder. At the time, swords and knives were standard personal weapons. They were the most common sidearm. Pistols existed, but they were slow, unreliable, and single shot. A sword was durable, reusable, and always loaded, per se. They were carried by soldiers, sailors, militiamen, gentlemen, and many civilians carried these, whether it was for self-defense, dueling, travel, or a social status symbol. Men like George Washington had a plethora of swords. They were carried in public as a symbol of authority, or your wealth, or your status in society. To dive even deeper, colonial statutes routinely listed required arms, especially for militia. And the list did not stop at muskets under the word arms. It included swords, bayonets, hangers, a short sword, cutlasses, pikes. If the DOJ wants to conclude that blades are excluded from the category arms, then early laws make absolutely no sense. The Second Amendment was written for the right of the people to keep and bear arms. Not firearms, not muskets, not technology existing in the year 1791, but arms, plural. So that includes firearms, bladed weapons, polearms, etc. Swords and knives were common, lawful, and carried by civilians in addition to militias and militaries. That places them squarely within what modern courts call arms in common use. So here's the part that the DOJ is choosing to miss in the brief that they wrote. Some cities back then regulated how blades could be carried, such as you couldn't conceal them, which we have those regulations on guns today. But those laws also assumed lawful ownership, public carry was normal, and they regulated the manner of the carry, not possession as a whole. And that mirrors how firearms are treated. Regulation does not equal exclusion from the Second Amendment. In fact, regulation presupposes protection. You don't regulate something you can't own. So the modern argument that the Second Amendment doesn't protect knives and swords is historically indefensible. If swords, being the primary personal weapon of the founding era, are not arms, then the word arms has been rewritten. The amendment has been narrowed beyond recognition, and the historical test collapses under its own weight. You cannot honestly apply the original meaning of our right and not include blades. And the DOJ's knife brief relies on a scary but familiar structure. That the Second Amendment doesn't defend all arms, only certain ones, and therefore banning these would be consistent with history. But this logic collapses when you place bladed weapons back in their historical roles. So just to recap, at the time of writing, swords and knives were more common than pistols, they were carried openly by civilians, they were standard militia and military arms, and they are explicitly listed under laws. So if the DOJ reasoning was applied honestly, it would require the absurd conclusion that blades are not arms. And history disproves that. So if swords are excluded, the word arms loses its meaning, militia laws become incoherent, and the Second Amendment protected only a narrow slew of arms that were never properly identified. You can't apply the originalist test and exclude the most common personal weapon of the era. So once we've talked through that, and we've admitted that swords are arms, knives follow naturally. The historically honest test asks 3 questions. Was the weapon in common use? Yes. Was it lawful to own and carry? Yes. Is it suitable for defense or military militia service? Yes. Swords pass easily, and knives, as an extension, do too. Since this is a meritism, and we go deep on the tism, Let's get into some actual legal precedents, both historical and modern, that treat knives the same way as they've treated swords. I'll break this into 3 layers that make this case much stronger than the DOJ will let on. Early American courts were explicit about this. They did not struggle that swords, knives, and similar weapons are in fact arms. Nunn versus the state of Georgia in 1846, one of the most cited early Second Amendment cases. The court held that the right to bear arms protects weapons of every description, such as are used by the militia, and then explicitly listed swords, dirks, bayonets, and pistols. That matters because dirks were knives, often short concealable ones, and the court did not say these are excluded. It treated them as arms whose manner of carry could be regulated, but whose status as arms were unquestioned. That mirrors how swords were treated. Arms first, regulation second. Reed versus the state of Alabama, 1840. The Alabama Supreme Court upheld a ban on concealed carry of weapons, but only after stating something critical. The legislature may regulate the manner of bearing arms, but cannot destroy the right itself. The weapons at issue included swords, knives, and pistols. Again, knives and swords are grouped together, not separated into protected versus unprotected categories. Here's layer 2. Let's deal into cases specifically dealing with knives, including switchblades. Delgado versus the state of Oregon, 1984. This is one of the strongest knife cases in American law. The court struck down Oregon's ban on switchblade possession under the state's right to arms provision, holding that a switchblade is an arm. It is a modern form of a historically protected bladed weapon, and the fact that it is easily concealable does not remove it from that protection. The court explicitly tied modern knives to historical swords and daggers. That directly contradicts Pam Bondi's DOJ's arguments that concealability somehow removes Second Amendment coverage. And here's the third layer. Even though the Supreme Court hasn't ruled directly on knives, the arms framework strongly favors them. Heller versus District of Columbia, 2008. Heller defines arms as weapons of offense or armor of defense. That definition is lifted directly from founding era sources, the same ones that unquestionably included swords and knives. Heller also emphasizes arms are not limited to firearms. The Second Amendment protects weapons in common use. Knives are more common than many firearms, more widely owned than a lot of NFA-regulated arms, and historically older arms than guns themselves. So nothing in Heller's reasoning excludes knives, especially when the sword was the paradigm arm of the era. Being that I'm from Massachusetts, I wanted to talk about one more. Saitano versus Massachusetts, 2016. The case dealt with stun guns, but its logic applies cleanly to knives. The court unanimously rejected the idea that a weapon must have existed in 1791 or must be quote-unquote military to qualify as an arm. If stun guns qualify as potential arms, it becomes extremely difficult to argue that knives, used continuously for centuries, don't. Bottom line, American courts have historically treated both swords and knives as arms. Knife-specific cases affirm constitutional protection. Modern Supreme Court doctrine defines arms broadly enough to include them to this day. And regulation has always been about how, not whether, such arms may be borne, carried. So when Pam Bondi's DOJ argues that this knife falls outside of the Second Amendment, it isn't following precedent. Any argument excluding them isn't grounded in history. It's grounded in convenience. Like and subscribe to keep building this community.